This is 24033318 Amber Properties Company versus Diana Campbell and Renee Ashley.
Ready, Your Honor.
So before we begin, I'm going to swear in the sign language interpreters. If you could both please raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge any confidential communication?
I do.
I do. All right, thank you. If you can just communicate with Ms. Campbell to let her know that you've been sworn in as the official interpreters in this case. Okay. All right. Could you please place your appearance on the record?
Yes, good afternoon, Your Honor. For the record, Tom Hocking with the plaintiff.
Thank you. And could I have each of you state your names for the record?
Renee Ashley here.
And I am Diana Campbell.
Thank you. Today is the date and time. I think the court recorder was just trying to confirm that she would be able to identify in the transcript which of the two interpreters was interpreting. Are we able to do that from the information you have? Okay. I think we're good to go. We had 3 motions that were scheduled on the docket today. These were motions filed by the defendants. The court has reviewed each of the motions as well as the responses that were filed by the plaintiff. Before we address the potential for oral argument, can I confirm for the record if the defendants intend to proceed with all 3 motions?
Yes.
On behalf of Ms. Campbell, thank you. Is there anything that either defendant, Ms. Campbell or Ms. Ashley, would like to place on the record in support of the motions that they filed?
Yes, ma'am.
Yes.
Ms. Campbell's asking, should I approach as well?
Yes. I just want to make sure that it's clear on the record if Ms. Campbell is providing an answer or any information in support of the motions that we're identifying that information is coming from Ms. Campbell.
Ms. Campbell said my daughter is going to ultimately speak for the most part, but I will still be here in support.
Thank you. Okay.
Your Honor, we're standing here today just to try to make sense of this. We apologize in advance that we're self-representing ourselves. Just to kind of give you an overview, we originally offered to pay June's rent upfront at the eviction hearing back on June 21st of 2023. We requested to vacate by July 31st, since they have offered to waive May's rent. They countered by offering to waive June's rent if we agreed to vacate by July 3rd, which we did. After that, they sent us the collection agency saying that we had owed this debt. I had emailed with Lisa Schneider in the past, which was their legal staff at the time, to dispute this collections debt. They have confirmed that there was no judgment ordered or no money awarded on this judgment. So I disputed that claim and sent it to the collections agency. Haven't heard since from them on this dispute. Continuing on, so we tried to go to Allstate Credit Bureau to see what was the agreement in between them and Amber Properties, because originally we were confused on whether or not, so we were confused on whether or not if it was Amber Properties that has the debt or was it Allstate Collections. In that fact, if it's Allstate Collections Bureau, then we feel that the plaintiff has no matter for this situation today that they presented. And so that's why we tried to do subpoena. We were denied by Thomas, and we have
Your Honor, this has gone on, I think, to the point of this hearsay is completely opposite of what the facts of the case are. It's neither in their motion or something that it's just not true. So for them to stand up without me being able to cross-examine them and put this stuff on the record is not accurate. So I'm disputing it. If they want to continue and put it on the record, that's fine, but it's false.
Okay. I'm asking them what the basis is for their motions at this point, and obviously I think the position seems to be that they want to give me background from their opinion. It's not anything that's being placed on the record under oath, and I'm going to give you an opportunity to respond. So to the extent that you take issue with the representation of the facts, I will give you an opportunity to respond when you can respond to the motions. You can proceed.
The letter that Allstate Collections Bureau stated that Thomas Hawkins, we can refer to them as, because we provided counsel to them. And so we never received information. We wanted to find out what was the agreement between Anchor Properties and Allstate, so we can really get to the core question of if we owe anything and who do we owe. We never received that information, so we feel that it's been manipulated and hidden from us, and that was really, so I just wanted to provide that information before proceeding.
So there's been a complaint filed in this court in the General Civil Division. It seems related in part to a previous landlord tenant case that was assigned to Judge Harding. Obviously, there's an opportunity for the parties to proceed to trial, given the position that you are disputing the basis alleged in the complaint for breach of contract. However, we aren't at the point yet where we would be addressing issues that we would address at trial. You have filed some specific motions that are on the court's docket today seeking relief. And that is specifically what I would need to have you address. One, it's fairly cut and dry as it relates to an extension of the dates and times that were provided in the scheduling order in this case. The other two, not quite as cut and dry. One, you're seeking the court to recuse or remove Mr. Hawking as the attorney for the plaintiff. So that's going to require some additional explanation beyond what you put in your motion. The others are related to some potential discovery issues that we probably need to resolve here so that it would be appropriate for the court to consider these discovery issues as a basis to extend the dates in the civil scheduling order. And on about every issue that's before the court today, it appears that the parties are diametrically opposed. They're not viewing things in the same way. So you have essentially made some statements in this motion where you're seeking to have Mr. Hawking removed as the attorney for the other side. Legally, I wasn't really able to determine a legal basis that I would have for doing that. There's some indication that because there was an attorney previously representing the plaintiff in the eviction, that somehow impacts the plaintiff's decision to retain Mr. Hawking to pursue this case. And I wasn't really sure what the legal basis would be for the court determining that Mr. Hawking had committed a violation of the Michigan rules of professional conduct to remove him. That's a pretty big ask. And I'm not really certain that you've outlined why that would be something the court would consider. Can you tell me what it is that you believe that you have to present?
So we tried to retrieve information from Allstate to make sure what is it that we owe and if we do owe them. And we feel that with him providing counsel to Allstate Credit Bureau and Amber Properties, it's a conflict of interest. I don't feel like I don't feel comfortable with that conflict of interest, and then possibly use the information that we need to provide a fair fight.
Okay, so if Mr. Hawking is providing representation to these two companies, they get to determine whether or not there's a conflict of interest. But based on what you've provided thus far, I'm not necessarily seeing a basis to disqualify him or remove him from a case and representing the plaintiff, as they freely have the ability to decide which attorney they're going to retain. I don't know that there's anything that you want to place on the record specifically, Mr. Hawking, as to that issue, in addition to what you've put in your response.
I'd just like the record to be clear that I don't represent Allstate. I never have represented Allstate. And even if I did represent Allstate, the court has identified the issue that wouldn't be enough to disqualify me. So I think the facts are confused even from the initial of this case, let alone this motion. So I just would ask your motion be denied.
Okay, so as it relates to that motion that you filed requesting disqualification of the opposing counsel, I don't believe that I would have a legal basis to do that. So I would be denying that motion today. The other two motions were related to the extension of the civil scheduling order and a request for the court to compel certain discovery from the plaintiff. As I said, I think the extension of the civil scheduling order is a fairly cut and dry request, but it seems to be predicated on this position that you're taking, that the plaintiff should have been providing certain discovery, but is not following through with their legal obligation to do so. And then, of course, the plaintiff is taking a different position on whether or not they would be legally obligated to provide the discovery that you're seeking. So can we go specifically to your motion where you're asking the court to compel Allstate to comply with the subpoena? What is the basis that you believe you have for the court to compel a non-party to comply with the subpoena in this case?
We need to know, so the whole reason for this case is that it's been accused that we owe a debt to Amber Properties. Because we had our hearing back in June 2023, we settled and there was no judgment awarded, no money was awarded, so we don't owe them. And so I have Allstate Credit Bureau coming after me, and then we just had them coming after me. So I don't know for a fact if they're coming after me and then, or coming after us and them too. I don't think that's fair, and I don't know if it's legal to have both of them to come after us at the same time. So we're asking, we just want to see that agreement that was agreed between Allstate and Amber Properties, which was the debt sold to them 100%. And in that case, then we can go with Allstate and deal with that matter after the fact, but, or is it Amber Properties that has that debt?
Have you asked for any other discovery during the discovery period and received it?
No.
Have you only sought to obtain discovery through the subpoena?
Correct, yes.
Did you provide any interrogatories to plaintiff through plaintiff's counsel requesting information?
Can you explain that, sorry?
So during the discovery phase, there are a number of things that you can do as a party to seek out information that you need to defend yourself against the lawsuit. Part of that would be submitting interrogatories or questions in the appropriate format for the plaintiff to answer within a certain time frame.
We did a request for admissions.
Okay,
And then this,
that was it. And did you get any information back as a result of your request to admit?
yes, the request for admissions we did receive.
Okay, and so let me ask the plaintiff, what is the position that you're taking on the motion to compel in addition to what I've already reviewed in your response?
Well, first of all, they obtained this subpoena without having a judge's signature on it or a court clerk signature on it. They just signed it themselves. So the subpoena itself is not sufficient, is improper. Secondly, I don't represent Allstate. They're not a party to this action. If the court wants to know, the procedure is plaintiff hires an attorney to do an eviction proceeding. Once they have their property back, they give it to Allstate to try and collect the debt. If Allstate is not able to collect the debt, then plaintiff hires an attorney, me, to collect the debt. That's what's happened here. There's no collusion between me and Allstate to hide documents. And in fact, there are no documents to hide. Allstate didn't buy the debt. She's indicated that Allstate owns the debt, or what did they buy? They don't buy it. There's nothing. They submitted requests to admit, and I denied that I was representing Allstate. I denied that there was any wrongdoing here, and they still continued with this improper motions that they filed. So I just don't think they understand what this case is about and how the parties relate to each other. But the simple matter is, Allstate's not a party to this case. They have nothing to do with the case. And whether they answer a subpoena or not has nothing to do with me. I don't influence them. I don't tell them how to run the business, and I don't tell them how to answer a subpoena or not.
Okay. Have you provided any discovery requests or interrogatories to the defendants?
No, Your Honor, I have.
And did you intend to do that at some point that would necessitate an extension of the discovery period?
No, Your Honor, I have. I don't need any extension. I'm ready to go to trial, and I think it would be a very short trial.
Okay.
Although I will indicate that this is a settlement conference also scheduled for today. I have a witness here for the settlement conference, but they didn't want to talk about any settlement before the hearing, so.
Well, it makes sense. They probably wanted to see what the court was going to rule on as far as their motions were concerned. But if the court issues rulings on each of the motions, and there's still an opportunity at that time to discuss the case because it was set for a settlement conference, they may feel differently. The amount that's in dispute here, is this correct? $2,195 plus prejudgment interest of $131.34. Is that correct? Mr.?
Yes.
Okay. And have they been given a breakdown of what those costs are attributed to?
Yes, Your Honor.
So given that information, it sounds like you were able to exchange some information during the discovery period. And for those questions that were directed to the plaintiff, it sounds like they provided the appropriate responses to your discovery requests. I can't hold this party accountable for another party that is not connected to the lawsuit, not a party to the lawsuit. I can't hold this party accountable for what another company does or does not do when they've received a subpoena that is or is not valid. So there's nothing that I could do to compel this company to get information from another company that's not a party to the lawsuit. It sounds like the position of the defendants is that the parties are related somehow, but that's not been demonstrated to the court, and legally, Allstate is not a party to the lawsuit. So I don't have any jurisdiction to order them to do something. And if you're telling me that the request to admit that you've submitted to this party, the plaintiff, those have been responded to, then from the court's perspective, they've completed the discovery that was sent to them.
In the request for admissions, there's been some contradictive information. And we actually have documentation from the Allstate Credit Bureau, and it says that provided by Thomas Hawkins as their counsel, please refer to him with any questions.
Okay. It sounds like Mr. Hawking is the attorney representing the plaintiff, and the plaintiff has utilized a collection agency to try to get funds that they believe that they're entitled to. And when those efforts did not turn out in their favor to obtain those funds, they turn to the attorney who then files the lawsuit at the court. So the process is not unusual. I don't know if there's some miscommunication about what debt it is that they are alleging that you owe. It sounds like they've given you whatever documentation they have about the account, but I don't know what other reason we would have at this point to delay the process. If you wanted other information from the plaintiff, through the discovery process, not the court enforcing a subpoena to a non-party. If there's other discovery information that you are seeking that you believe is able to be obtained from the plaintiff and you need an extension, we can do that, but I would not order the plaintiff to do anything regarding this subpoena that was sent to Allstate, and I don't have the jurisdiction to order Allstate to do something. They're not a party to this case. So is there anything else from a discovery standpoint that you believe is still outstanding or that you would need to complete for the plaintiff?
For the plaintiff?
Okay, and I think I saw that we were actually looking at a deadline that had already passed for discovery. So let me double check that.
Can you repeat that? I couldn't hear.
I wanted to see what our deadlines were. Discovery ended January 26th, so it's been over for a while. All motions dispositive or otherwise have to be filed on or before February 25th, which is the date that you filed these, and we set this for today's date. You're indicating that no additional discovery would be directed to the plaintiff. So I don't know that we would have a reason to extend the discovery timeframe. Settlement conference was supposed to be scheduled for today, so that's a time in which the court requires the parties come to court and they have a representative that has the authority to discuss settlement. It sounds like the plaintiff has that person here today, and the two of you are the parties that would have the authority to discuss settlement, so you upheld your end of the bargain. At this point, I'm denying the motions, all three of them, because I don't have a basis to grant, I don't think, any of them. We can have an opportunity for you to go out and discuss the case, or I can also provide an adjournment of the settlement conference before I look at setting a trial date, if you'd like some opportunity to take some time before you proceed to a settlement conference. Or we can do both. You can go out and have a conversation today about the potential for settlement, and then if needed, we could also grant an adjourned date for a settlement conference.
I can see both.
Okay, so that's what I'm inclined to do today. I'm going to deny the motions for the reasons that I stated on the record, knowing that that's a decision the court has made with the reasons I've provided. The parties that are here and have the authority to discuss a potential settlement can have that conversation, but I'll also adjourn a settlement conference date out a couple of weeks in case there's a need to continue the discussion, or if you're not able to discuss today and want to return on that date to discuss settlement. At that time, if there's no resolution, we'll talk about how the case proceeds, which will likely be picking a trial date, okay? Anything else for the record? And plaintiff's counsel?
No, Your Honor, I think that's a good way to proceed.
All right,
Hopefully we can settle it today.
okay. Thank you, that's it for today.
Thank you.